I got a lot. Let's see. Foxy Brown is to testify in the Tupac unaliving. I got some on um young see Young Thugs lawyer. But him and the judge ain't getting along too hot. I'm gonna show you a little bit of that. And I want to give a shout out to Tough News TV. Tough News TV. All right, I'm gonna show y'all what I got. Okay.
Baby, Foxy Brown may be called as a material witness in the Tupac case. Yup. Who would have thunk it? Because I did. Prosecutors reportedly want Foxy Brown to testify in the Tupac unaliving case. So according to prosecutors, Dwayne Keith Davis mentioned Foxy Brown in his biography when it came to the unaliving of Tupac. So Dwayne Davis' defense is saying that he was never in Las Vegas and they have no material evidence to put him there except for his biography, which he was doing that to get fame and to get money. Baby, you told your story. Now you got to ride with it. So according to somebody that's running their mouth that shouldn't be running their mouth, Foxy Brown could prove vital to taking the stand or even making a statement about her recollection of being around the men who claimed they were in company for a short while before they set off to take Tupac out. Now, prosecutors really need Foxy Brown to come through because this will put Keith in Vegas. It will put him in the place that he claimed he was in his book that was published in 2019 called The Compton Street Legend. Baby, you are not a legend. You are a disappointment. Now, Davis claimed he saw Foxy Brown on the night of the Pow Pow while she was in the car with New York City party promoter Eric Zip Martin, who is no longer alive, so he cannot help in this situation. Now, get this. Davis claims that Eric Martin was the person that gave him the piece to give to his nephew Orlando Anderson to take out Tupac. Now, this is an excerpt from his book. As I walked up to the driver's side window, I noticed that the rapper Foxy Brown was in the car with Zip. This was in the main event chapter. Davis goes on to say, so he instructed her to step out of the car and motioned for me to jump in. Zip had a hidden compartment that he opened up, reached in, and pulled out a black 40 Pow Pow. Now, I'm going to let y'all pause and read the rest. All I know is we know Foxy has been through hell and high water, and she may not remember. She may remember, which I really hope she does remember, so that could help move this shit along because the trial starts next summer. Peoples, were y'all expecting this? Because I sure wasn't.
All right, so you guys just heard all of that. So it seems as though the prosecutors within this case are turning up the heat and they're looking for Foxy Brown. They basically need her testimony to move forward and things of that nature. I'm pretty sure that Foxy doesn't want any parts of this. You know, she does follow the code of the streets. She's always been a down A chick, but it's really nothing that she can do. If she's subpoenaed to go to court and talk about this situation, she can get on the stand and act like she's not coherent, like she doesn't remember anything, but she needs to tread lightly because she doesn't want to get convicted or charged with perjury, you know, lying on the stand and things of that nature, especially if they...
All right, y'all heard that. Foxy may be called to testify. And as far as the, wait a minute, let me find it. As far as the Young Thugs case, oh boy, that's going, from what I've seen of it, it is a trip. I'm going to show some. Let's see. I'm trying to get it all set up, okay? Okay, because, let's see. Alright, I think that, let's see, wait. Okay, alright, here we go. Here we go. Okay, listen.
Check out this clip, and then I'll be right back.
I'm not a lawyer, but day 88 of the YSL trial was crazy. Let's talk about it. Context before we get into it. Last Friday, a man named Kenneth Copeland, this guy, was called to the stand to testify. Copeland is a key witness for the state and this case. But when he comes to the stand, he ends up pleading the fifth. The judge throws him in jail for contempt and tells the attorneys that there's going to be a hearing on Monday, meaning today, to ask if Copeland plans on continuing to plead the fifth or if he's going to testify. Another key thing to know here is on Friday, Copeland's attorney, whose name was Melnick, said that he couldn't attend today, Monday, because he had some non-refundable tickets. So the attorney Copeland had on Friday is not the attorney that he had today. Now this is all key information, so stick with me. So today comes and court was supposed to start at 8:30 this morning, but there was a delay. And by the time Judge Glanville takes the bench, it's around 11 o'clock. Once that happens, the judge says there's actually been an update.
Mr. Copeland's had the opportunity to speak with his lawyer, Miss Bumpus, and it is my understanding he's going to testify. That's the latest I can give you, okay? So we're going to bring Mr. Copeland out, and we'll see what happens.
Copeland takes the stand and gives his version of a testimony.
I got said back.
When is your birthday?
Next month.
Did you grow up in Mechanicsville?
For sure.
How many brothers do you have?
More than one. I think 3. Trey, not a boss.
Or you just give me the first name?
I just did. I guess.
All right.
I don't know. I went to a lot of different schools. I don't recall all of them. I only know one.
Are you married?
Nope.
Do you have children?
You know that. More than one.
Do you have more than 3?
I might. Ain't no telling.
Okay.
I don't know. Y'all been having me in jail so long. I can't recall.
Were you in jail on Thursday?
Thursday ain't came yet.
No, last Thursday.
I felt like it. I don't know their ages.
Are you currently working?
I'm in jail. Don't keep up with it. Driving without license. Driving with suspended license. Running from the police. I go to jail for the charges y'all throw on me. You tell me? What did I take? I don't know what happened in 2009. Probably so. I don't know. Never heard of that. What's that?
Did you ever take a drug charge?
Oh, that's the charge y'all put on me
When did you get out of prison for federal charges?
when they let me go. One of these years. Y'all locked me up so much. I can't read.
Do you know someone by the name of Shannon Stillwell?
What's his nickname?
Okay, what do you call Shannon?
I call him Shannon.
And do you see Shannon in the courtroom today?
But I got a vision problem. I
Okay.
can't see that far. Who am I looking for? I think I see him. Looks like he wearing gray over there. I think he got red hair.
Okay, so you pointed to a lady and not Shannon. At some point in time, did you ever develop a friendship with Shannon?
I don't know when, but at one point we became cool.
And when you say cool, what do you mean?
COOL. You gotta be Pacific.
Sure.
I go out with anybody, even you.
I'm not asking about me. I'm asking about Shannon.
Hey, Judge.
Sir.
I'm hot. Can I take this sweat off?
Can we just we're going to recess, ladies and gentlemen, for 5 minutes, okay?
So after they remove Kenneth Copeland's sweater, the judge calls the jury back in and says it's time for lunch.
We had to take up some ancillary business, and it's the lunchtime hour at this point in time. So what I was going to recommend we do is
Everybody goes to lunch, and before court resumes for the afternoon, Brian still says he has something he wants to address.
I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, he did not come into your courtroom until almost 11:30. And what I found out is that supposedly in chambers, this honorable court reporter at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information and belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information and belief, that Adrian Love, the lawyer for Mr. Copeland and this court, were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying, F you.
Wait, he just said Kenneth Copeland's attorney that came into the courthouse on Friday sent an email to Adrian Love that said, F you?
To me, that never...
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason is...
I'm asking you a question.
And I'm
How did you find out about it?
The premise Steele is setting up is that through the weekend and up until today, Kenneth Copeland had maintained that he was going to continue to plead the Fifth. Then this morning, there's this massive delay to court starting, And Steele says during that delay, Kenneth Copeland, his attorney, the judge, the DA, and investigators were all in a meeting in the judge's chambers. And following that meeting, Kenneth Copeland all of a sudden agrees to testify. And the problem, according to Brian Steele, is that a judge, DA, and a sworn witness can't have a meeting together in the judge's chambers without the presence of the defense. But the judge is telling him, not only can we have a meeting without y'all, the larger problem here is, how do you know about that meeting? Because anything that happens in a judge's chambers is supposed to be private. So Glanville's issue is, you need to tell me how you heard about this meeting. Oh, and ex parte just means one party. So the judge and the DA, or the judge and the defense, those would be ex parte meetings with no witnesses.
We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, it's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not
How
going to
did you
answer that question.
You're not?
No, I will not answer that question.
Why would you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to put anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
a witness who was sworn in Friday. The court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court.
Okay.
Or excuse me, let me rephrase that. This court.
That was shade. He went from this honorable court to this court.
Supposedly said, I can hold you until the end of this trial. Ms. Sultan supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there?
Remember I said all of a sudden Kenneth Copeland agreed to testify today? Right here Steele is asserting that Copeland was coerced and threatened, and that's why he agreed to testify. And according to him, the judge was a party to, or at the very least, a witness to that.
Why, sir? I'm going to hold you in contempt if you don't tell me who this. Tell me who this information was.
I don't want to be held in contempt. Well, then answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out. I tell you what, I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Now, if you've been watching, you know the death of Donovan Thomas has been discussed in this trial for at least the last 2 weeks. It is count 2 in the indictment and what some of these defendants are charged with. And Brian Steele just said that in this morning's meeting, Kenneth Copeland admitted to being the triggerman in that death. So the judge gives him 5 minutes to think about if he's going to tell him how he got the information, but Brian Steele ain't budging.
I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others.
Why would it be ex parte?
What do y'all think? What do y'all think? Do y'all think he admitted to doing the pow-powing? That judge is... Oh, Lord. I wonder what can they... Oh, my gosh. Oh, well. But that lawyer, stand your ground. Stand your ground. Stand your ground. And in my opinion, if he put me in jail for something that they allegedly did behind my back as a lawyer, then I would sue him. And that's what I would do. That's just me. I don't know the law, though. Okay, let's just see what's going on right now. Let's just see. Whoa, what a courtroom. What a court. I'd have loved to have been there.
You act like it's ex parte under
It's ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness. Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to judge it.
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
This is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information belief,
From whom?
part of it.
From whom?
Well,
You need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. There's only one other person that's left.
well, Your Honor.
And if that person gave you that information or shared that information with you, she probably violated privilege.
Well,
The person he's talking about here is Kenneth Copeland's attorney. The judge is saying she's the one who told Steele about the meeting. He also, a second ago, implied that maybe Brian Steele was eavesdropping. But regardless, Brian Steele is saying he can't reveal the source of the information.
Who gave you the information?
I'd like to know what information happened outside our presence. That's really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with the
which is appropriate.
and you influenced the witness based on information belief, and I'd like to have that all in the record. I'd be breaching 1.6, and I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
They can't hide behind. Yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
1.6 has to do with attorney-client privilege, but Brian Steele also referenced work product privilege, which has less to do with the communication between a client and their lawyer and more about that lawyer's work on the case and information or documents that they may come across and for the case.
Unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with.
And Your Honor, and I know I said this previously,
Yes, sir.
but we are not accepting any proffer from this.
Okay. Excuse me.
Okay. All right.
Ms. Love essentially said the same thing that the judge said. Basically, this is crazy. We need to know where he got the information. So I'm only going to play a couple things from her.
This is a matter that the defendants did not have a right to be a part of. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information. I don't know if the information was leaked to his client from someone who was in chambers or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6.
Once Miss Love is done, Keith Adams, who is the co-counsel for Young Thug, he comes up to the stand to give his side.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams. He has two attorneys.
Okay, yeah, he does, but
The court, now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court is engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information we've received. And if Mr. Steele is going to be held in contempt, I have exactly the same position.
Keith Adams said, one band, one cell. Okay, but he also, in addition to also requesting a mistrial, is asking for the transcripts from the meeting.
I also do not.
well, I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay.
Max Shard is up next to the podium.
When is it, Mr. Sharp?
On behalf of Shannon Stillwell, I am going to be moving for a mistrial.
Shard also goes over the events of the morning.
Today, we were instructed to come 8:30 for a 9 o'clock start. We did not start till approximately, I'm estimating 11 o'clock. We figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark, and quite frankly, we kind of remain in the dark. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, Your Honor. Thank you.
Noted your motion for mistrial. It's denied.
Mistrial denied, and the other attorneys also asked for a mistrial, and Glanville denies them all. And then Brian Steele is officially held in contempt.
Okay, Mr. Steele, last time. Who told you? All right, Mr. Steele's in custody, and once he clears the area, we'll go ahead and get started.
If by that point we get started with the trial,
Yeah, we're going to continue. I'm not called nothing.
I participate in the trial without stealing.
You don't have that luxury at this point in time, sir. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't. Sir, you all are really getting yourselves cross purposes at this point in time. He's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again? Sir, you have to. Well, you're gonna have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been.
Okay, well then you've made your. No, we're not doing that at this point in time. So, all right, take Mr. Steele into custody, please.
Would the court afford me 1 moment to confer with counsel regarding the appropriate remedy in this type of
Okay, all right. Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me against his will and my will. You take away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I denied your motion, but I'll certainly take that under advisement, sir. We're going to be in recess for the next 5 minutes.
I gotta come back to tell you what happened for the rest of the day, because more happened, more than just this.
I'm going to order that you be taken into custody and incarcerated in Fulton County Jail for no more than 20 days for this contempt. Those 20 days consisting of every weekend for the next 10 weekends. And you'll be reporting to 901 Wright Street Northwest, Atlanta, Georgia, 30318 at 7 p.m. on Fridays. You'll be released on 7 p.m. on Sundays. And it's to commence this Friday, June the 14th at 7 p.m. and not to end until Sunday, August the 18th at 2024, 7 p.m., subject to further order of this court. And that will be entered and e-filed. You may take whatever steps you and your counsel deem appropriate after that. Okay?
What? Can I ask you a question?
Sure.
I'm going to file a notice of appeal, but for whatever reason that doesn't take, and you don't give a bond, then I'd ask that I can be with Mr. Williams and we work on our case all weekend, for all those weekends. Otherwise, I can't prepare. I speak with Mr. Williams all the time.
That's up to you. And sir, I will. If that comes to pass, you have my support. I will talk with our sheriff and we may be able to make that work. Okay.
I'm an attorney in real life. I don't play one on television. Let's talk about whether the judge in the YSL case can be removed from the case. Brian Steele, Young Thug's attorney, was held in contempt today and arrested briefly, and he has now been sentenced to do 20 days in jail on the weekends. So people want to know if the judge in the case can be removed or if there's someone in a higher authority who can do something to discipline the judge for the decisions that he's making. The answer to that is no. Judge Glanville is actually the chief judge in Fulton County. Judge Glanville has been on the bench in Fulton County since 2005 as a Superior Court judge. Before that, he was a magistrate judge in Fulton County. He was just reelected to his position. He did not have any opposition, so he didn't really have to run for his position. In Georgia, the way that judges are disciplined is through the Judicial Qualifications Commission. If you have a complaint about a judge, you file it with them. They investigate, they can hold hearings, and they can ultimately decide if a judge should be disciplined. So no, there is no other person who can step in and say, Judge Glanville, we don't think you're doing a good job in this case and you should be removed. And Judge Glanville is the only person who can decide whether there is going to be a mistrial in this case. He has repeatedly rejected the idea that there should be a mistrial. He did so today when Brian Steele asked for one because of the ex parte communications. So let me know if you have any other questions about the process in Georgia for removing judges or the judicial process in Georgia.
Well, that is about the craziest thing I've ever heard. Ever. Dang. See. They call Will Smith. He may be able to pull some strings. That's a good one. Hey, Matissa. Y'all please subscribe to my channel, Valentine TV. Thank y'all so much for hanging in there and watching. Okay? Alright. I'll talk to y'all later. Y'all be good. Please remember to pray for my mother, who I had to take to the emergency room this morning. She's back. She's healthy, doing fine. Y'all just say some little prayers. Thank you. I love y'all. Bye.